we are talking about pre-trial release or detention of suspected federal criminals. Release or detain. This is the 5th video, and we're now up to the point where we're talking about if a magistrate decides to either release or detain the defendant, what happens? What happens when the decision made to release or to detain happens? Well, like everything, there is an order, right? A judicial order. When judges make decisions or magistrate makes decisions or any judicial officer makes decisions, puts in writing, you have a judicial order. As a reminder, we have gone through 1341 and 1342, again, the Bail Reform Act of 1984, Chapter 27, Section 1342 is where we're at. We have covered A through G already. Alpha through Golf, we've covered A through G. We are now on H, if you are following along. H for hotel is going to talk about a release order. A release order. If the magistrate or judicial officer wants to release the defendant, we're going to be talking about release orders. Okay, so there are a number of things to consider as far as what goes on the order itself. On the order, there are at least three requirements that need to be there. The first is that it needs to be clear and specific as far as the requirements, right? Are there conditions? Are there limitations? They need to be clear and specific so that the defendant is perfectly clear on what is required of him, right? If he has to keep his job, it needs to be absolutely clear that he must keep his job as a condition of his release, right? Any part of the release agreement goes on the order, right? It is a written verification that there is a contract, that there is an agreement. Okay, that is thing number one. The second thing are the penalties or consequences if the defendant does not keep his agreement. If he does not keep his agreement, he needs to know in writing, it needs to be on the order, so there is no question what the consequences or the penalties, what they're going to be if the defendant violates those conditions. Okay, so any part of release. So we discussed 3 different ways of releasing defendants, right? We talked about on personal recognizance, or we talked about unsecured bail, which are all part of the first one. Then there's conditions, right? And we talked about the 14 enumerated conditions if the magistrate or judicial officer wants to release the defendant, but on a condition and not on the defendant's own word, right? Sometimes the promise of the defendant doesn't really carry much weight. So the magistrate or the judicial officer will put a condition on it, right? What are the consequences if they don't keep their job, right? If they quit their work, if they quit going to school, if they go to a location they were prohibited from going to, if they get caught with a firearm, right? We see that in movies a lot. People getting rearrested for carrying firearms when they're on conditional release not to carry a firearm. So again, the conditions are really important. When a defendant promises to uphold a condition, they're held to that promise. Okay, the third item that goes on a release order is going to be a provision saying the defendant cannot intimidate a witness, a juror, or anyone else that would be a part of the process, again, of bringing a charge or a legal criminal action against the defendant. We're not going to let them go so that they can go and destroy our case against them. They can't intimidate witnesses or jurors or anyone else that would be involved in the process. They also cannot obstruct justice, right? So these things have to be included. Again, the defendant has to be absolutely clear, no doubt in the defendant's mind whatsoever, what the conditions are or what the terms are to their release, what the consequence is going to be if they do not uphold the terms they're agreeing to, and a statement that they cannot witness tamper or mess with the jurors or victims, right? We don't want them to cause any further harm to victims, and they cannot obstruct justice. So at a minimum, those things are going to be on a release order. Again, so a magistrate has the option to release or detain. The legislative branch, they strongly favor release, right? Release over detain. But if a defendant has to be detained without other reasonable options, they get a detention order. So if they're released, they get a release order. If they are detained, they get a detention order. What goes on this? Well, at least 3 primary things goes on this as well. These are the minimum. There has to be a written statement for the finding of detention. Again, the magistrate or judicial officer must show a reason why the person was not released. This is the complete opposite of how it used to be. It used to be that the standard was you're not going to go anywhere. And maybe if you can pay a large bail, we'll let you go. And now it's, if we're not going to let you go, we need to show why. And it needs to be very, very specific, right? Why did the first 3 options for release, why were they not reasonable options? Why could none of those work? And why couldn't we have used a less restrictive method? Why are we going to option number 4, which is just detention, right? So the finding for detention, it must be on the detention order. Okay, so that everybody is perfectly clear why the person is being detained. Okay, it's not just willy-nilly. It's not because the judicial officer did not like them or did not like what they were wearing or did not like the fact that they're out allegedly committing crimes. None of that is good enough, right? They have to state their findings for why the person is being detained. The second thing is that the defendant is going to be turned over to the custody of the Attorney General. The Attorney General, remember that term is a federal term. The Attorney General. The Attorney General, that is our federal attorneys, the attorneys that work for the federal government. Okay, the Attorney General. If you have a state action or a local action, you're likely going to have a state prosecutor. If it's federal, you're going to have the Attorney General. The Attorney General. Note that under this, there are instances where a defendant might get remanded to the custody of a federal marshal, say if they need transportation or anything like that, but ultimately they're going to end up with the Attorney General. Remember, we are federal. This act is federal. The Bail Reform Act of 1984 is a federal act that applies to federal courts and federal crimes. Okay, the last option under this, and I forgot to mention that we are in I. We are in I. So 27 USC 1342I, the last option there is, or the last requirement to go on the detention order is the right to private counsel, right? So we have to give these defendants the right to private counsel. The right to private counsel. And one of the things the magistrate is supposed to do during the initial appearance is to ensure that the defendant's rights have not been violated, right? And again, mostly because we're talking federal court, we're talking about the rights granted in the Constitution or other federal documents, right? So the 4th, the 5th, the 6th Amendment, and the 8th Amendment are where our protections for federal criminal defendants come in, right? So the 4th Amendment, 5th Amendment, 6th Amendment, and 8th Amendment, we want to ensure that the rights of the defendants have not been violated. Okay, we also want to let the defendant know and make sure that they know what their rights are before going any further. Okay, so those are things that go on the detention order. So now we've talked about the release order, if the court is going to use one of the 3 options to release a defendant, and what goes on the detention order if the court or the judicial officer feels that they must detain and not release a defendant. Okay, J, our very last thing we're going to talk about in these first 2 sections, J just restates that there is a presumption of innocence, right? And again, that is the big premise behind this Bail Reform Act of 1984 is to change the system, to say, yes, we say that defendants are innocent until proven otherwise, but then we make them pay bail, or we keep them in jail even before we prove they've done anything wrong. So this, it just is a reminder there is a presumption of innocence, right? We are no longer just taking money from defendants. We're no longer making them get bail bonds. We're no longer making them go through third-party companies to try to get assistance to get out of jail when they maybe didn't have to be there in the first place. We're trying to release. We want to release, right? Catch and release our federal criminal possible defenders, right? Or offenders. So again, this was the Bail Reform Act of 1984. It is a federal act, an act of Congress that applies to federal courts, This was the last video of 5. If you missed any of the 4, you can go back up and see any of those. But great job on the Bail Reform Act. I know it's not an easy document to get through, and we did only cover the first 2 sections, but really great job.